Yes, Mr. Straw.
My lords, my lady, I represent the appellant alongside Ms. Knorr. Mr. Holborn and Ms. Sullivan represent the respondent in this case. I propose to take the issues in the following order, if I may. To firstly look at the policy in place relevant to the issues in this case. So that's both the Ukraine Family Scheme criteria and also the policy on leave outside the rules. Then turn to the decisions in this case. Then to look at evidence of the intentions of the responsible minister in formulating the scheme before turning to the grounds of appeal and taking those in the order they appear in our skeleton arguments. And then looking at responses to the respondent's additional reasons for upholding the appeal. Between us, we'd proposed that I deal with those in opening. If the court would prefer to hear from Mr. Holborn first and then I respond to them, we're happy to do it that way. But it seems a little easier for me to deal with those in opening.
Let's see how we're doing when we get there, so to speak.
In terms of timing, we put in place maximums, which is that I can't go beyond 3:15 p.m. today and Mr. Holborn beyond 12:15 tomorrow, but it may well be that we finish.
Yes.
So then looking at the first issue, the policy in this case, and could I turn please to the Ukraine Family Scheme criteria? Those are in the authorities bundle, and could you have a look at that please, at tab 3. It's authorities tab 3. And then page 15.
Yes.
So to be eligible under the Ukraine Family Scheme, the first requirement is residence. That's in UKR 5.1. An applicant applying for entry clearance must have been ordinarily resident in Ukraine on immediately before, the 1st of January 2022, and that was the date of the Russian invasion. It's uncontroversial that the appellant meets that criteria in this case. That's the upper tribunal's judgment at paragraphs 39 to 40.
Yes.
They noted he was ordinarily resident on that date. Indeed, he'd been in Ukraine since 2015, since sometime before the invasion.
So, sorry to interrupt, Mr. Straw. So this is an appendix to the immigration rules. So you described it as a policy, but it is actually in the immigration rules.
Apologies, yes, it's in the immigration rules. Yeah.
So it's got a slightly different legal status if it's in the immigration rules as opposed to just being an executive policy, in part because the immigration rules are subject to a parliamentary procedure.
Yes, absolutely. Under Section 3.2 of the Immigration Act 1971, subject to negative resolution.
Yeah.
So that's the residence requirement. The second requirement to qualify under the Ukraine Family Scheme is the relationship requirement, which is set out in UKR 6.1. And this might be broken down into two elements. One first has to show that the applicant has one of the specified relationships, so a family relationship, and one also has to show that the person they're related to is settled in the UK. So that might be broken down into two criteria. A sort of sponsor element, is the sponsor settled, and a relationship element. If it's looked at that way, the sponsor element is in UKR 6.1. So the sponsor has to be either a British citizen, a person who's settled in the UK, a refugee, or an EEA national, as in little d. And for convenience, I'm going to refer to all of those as someone who's settled in the UK.
Yes.
The next aspect of UK, of this part of the rules, is what might be termed a relationship requirement. So the applicant, this is 6.2, the applicant must be a family member in one of the relationships listed in UKR 6.2. So those include an immediate family member, which is in paragraph A, partners, children under 18, fiancés, civil partners, and so on. Also an extended family member, so that's in B, and that extends to quite a broad group of people, grandparents, grandchildren, siblings. So that's the appellant in this case meets that criteria. He's an extended family member because he's a sibling. Aunts or uncle, cousins, nieces and nephews, and so on. And in addition, C, an immediate family member of an extended family member. So, for example, one can be a fiancé or a proposed civil partner of a nephew of the person settled in the UK. So it's a relatively broad group of people. The final requirement for eligibility under the Ukraine Family Scheme is 7.1. So this is on page 18 now. And the applicant must either be a Ukrainian national or B, a little bit more complicated, part of a family group, meaning a group of people as set in UKR 6.2, which includes an immediate family member of the UK-based sponsor who is a Ukrainian national and who would qualify under the scheme, whether or not applying at the same time as the applicant. So, so for example, a person who is an extended family member, a cousin, a nephew, or even 6.2c, the immediate family member of an extended family member, so the fiancé of a niece, the fiancé of a nephew. That very large group of family members in 6.2, all of them can qualify under the scheme, even if they're not Ukrainian nationals, provided that there's at least one Ukrainian national who is an immediate family member of the person settled in the UK. So take this case, for example, a hypothetical, but if QR, who's the person settled in the UK, if his fiancée was Ukrainian and she qualified under the scheme because she was resident in Ukraine in the date of the Russian invasion, then everyone else from QR's family, even if they're third country nationals, so they're not Ukrainians, would also qualify. So it's a potentially very large group of third country nationals which qualify under the scheme, providing there's that one immediate family member who does so. A does not meet that criteria, so he doesn't fall within 7.1. He's not a Ukrainian national, and he doesn't. He can't bring himself within B either. However, his case is that, so far as the main purpose of the scheme is concerned, he's in a relevantly similar position, and that's because he's unable to return to his country of origin. His brother QR has been accepted under ARAP, and LR, so the appellant, has also now been accepted under ARAP. He's been found to be eligible under ARAP. The upper tribunal, at paragraph 2 of its decision, noted that the appellant could not return to Afghanistan because he feared for his safety. It noted he's a refugee. And indeed, in the decision, I'll come to it in a moment, but it appears to accept that he couldn't return to his country of origin. So his case is that he's analogous because he's unable to go home. He's in terms of the core purpose of the scheme, which is to protect people at risk as a result of the Russian invasion who have family in the UK, we say he's analogous.
Just to, so he has been accepted under the Arab scheme. I don't think we've got the document, but tell us what date it was and what its effect is.
Yes, so his brother applied under ARAP back in February 22, and his application included an application that LR, the appellant, would come over by Arup. And then on the 23rd of September 2024, the appellant was found to be eligible under the Arup scheme. There's a second stage to Arup. There's first the eligibility consideration, which the Ministry of Defence does, and then the second stage is the Home Office deciding whether to grant a visa. We haven't got to that stage yet, so it's been referred to the Home Office, and the Home Office have said that a visa decision is expected in June 2025, but we don't have that final decision yet. So there's still a possibility that he'll be refused the visa under Arup.
Is he physically in the UK at the moment?
He is, yeah.
So how did he get into the UK if his application for entry clearance was refused?
He came over without permission.
I see.
So it was the 19th of July 2024, after the upper tribunal decision, he came over to the UK without permission.
Yes.
So those are the scheme, the Ukraine scheme criteria within the immigration rules, but the policy on leave in this area extends beyond that. There's also a policy about leave outside the rules, and I'd like to turn to that, please, if I may. It's in the authorities bundle at tab 37. And that's page 1288. Tab 37, page 1288. This isn't part of the immigration rules, it's a separate policy produced by the respondent. This was the version that was in force at the time of the most recent decision. That's the key decision under challenge. And could you turn, please, to page 1293? Um, 1293, at the bottom of the page, there's a section heading Supporting Evidence, which goes over onto the next page. And it describes the approach that decision makers should take to evidence of the criteria under the scheme.
Sorry, just, I'm sorry to interrupt you again, Mr. Straw. Just to go back, page 1291 about this guidance. This guidance tells decision-making caseworkers how to decide applications for entry clearance or permission to stay on the Ukraine family scheme. So is this guidance about how to make decisions under the appendix that we've just been looking at?
Yes.
Right, because you said it was something about leave outside the rules. But at the moment, it seems to me that this looks as though it's guidance about how to make decisions under the rules.
This part of it is,
Right,
but
okay.
I'll come to the part about leave outside the rules in a moment. So on 1293 going over to 1294 is the section about supporting evidence. And what it essentially says is that the burden is on the applicant to prove the relevant criteria. Decision makers should be mindful of the difficulties that people face in providing documentary evidence in this situation. However, decision makers can ask for further evidence if they think there's insufficient information provided with the application. So it's a sort of flexible approach to evidence in these cases. And then 1308 is the part on leave outside the rules. Um, 1308 has a section headed Appeals and Administrative Review. And towards the bottom of the page, so 2 paragraphs up from the bottom, there's a paragraph that starts, if an applicant for permission to enter raises human rights issues within their entry clearance application, and they do not meet the requirements for the Ukraine schemes, you should consider if there are any exceptional circumstances which would warrant a grant of leave outside the rules. So decision makers should consider leave outside the rules for applications under the Ukraine Family Scheme which don't meet the Ukraine Family Scheme criteria. It's not necessary to make an application under, for example, the family route or to pay a fee for leave outside the rules. It's expected that decision makers will consider leave outside the rules for someone who applies under the Ukraine schemes.
And I think that happened in this case, didn't it?
It did, yeah. So that's the what I refer to as the policy framework for leave decisions. Could I turn, please, to the decision in this case? There are 2 very similar decisions that were under challenge. The first one was on the 2nd of May 2023, and that was the one challenged in the claim form. But subsequent to the claim being made, another decision was made on the 15th of February 2024. It's almost identical, except that the decision maker addresses some new expert evidence that was put forward and adds a few reasons. And so unless you prefer me to look at the May 23 decision, I'm just going to look at the 15th of February 2024 decision.
Yes.
And that's in the core bundle. Could you please turn up the core bundle? It's tab 21, please, page 234.
Speaking for myself, I don't have tabs in the core bundle, but never mind. Page 234?
234, yes. Yes. Thank you. So this is the 15th Feb 2024 decision. It's headed as being, in the first paragraph, as being a decision under the Homes for Ukraine sponsorship scheme, but there's no dispute that this also covers the Ukraine Family Scheme. See the upper tribunal judgment at paragraph 7. Over the page, there are, firstly, the reasons for the refusal, which are you don't meet the requirements of the scheme, and then the decision. And in the section headed the decision, 4 lines down, it's noted, it has also been considered whether the exercise of discretion outside the rules is appropriate. So that's my lady's point just now. It was considered in this case whether to exercise that discretion outside the rules. And the decision maker wasn't satisfied that he met the nationality requirements. Over the page, there's the consideration of Articles 8 and 14 to start with. And then to the bottom of the page 236, there's the exceptional circumstances and discretion to grant leave outside the rules. And there's a pretty long section analysing the individual circumstances of his particular case. The decision maker notes, I've looked through the evidence provided, That's towards the bottom of page 236. Over the page on 237, second paragraph up from the bottom, about 3 lines up from the bottom of the paragraph, the letter notes, I also acknowledge that you've provided the reasons why you would be unable to return to Afghanistan. So it appears to be accepted that he can't return to Afghanistan.
I'm not sure that necessarily follows. I acknowledge you have provided the reasons why. What's acknowledged is that the appellant has explained why he says he can't go back. I mean, I don't think it's a clear acknowledgement that he can't go back, is it?
No, that's fair, but I suppose the best way of putting it is that there certainly isn't a case where the decision maker is saying, I can't make a decision on whether you can go back, or I don't accept you can't go back, or anything like that.
Right.
It's put as it is there.
What it seems to amount to is, even if that's right, you're safely located in Germany with family members, and what's wrong with that? That's what they seem to be saying.
Yes, absolutely. I mean, the immediate response to that is that could be said for any applicant under the scheme.
Well, could it? I mean, it depends on what their circumstances are.
Yes, but people who meet the eligibility criteria, so a Ukrainian national or a third country national who falls into 7.1b, aren't rejected on the basis that they're in a safe country. So if they were in Germany, France, if they were in a safe country, they would nevertheless be eligible under the scheme.
But this is outside the rules where we are at the moment, aren't we?
Yes, that's right.
Yeah.
So over the page at 238, there's a section right at the bottom of the page headed Difference and Treatment. And this addresses the argument that the appellant had made that refusing him leave would be a breach of Article 14. And I'm going to come back to this later, if I may. I'm sorry to jump around, but there are just 2 points I wanted to look at now for the purpose of understanding the decision. The second paragraph down is said, in the evidence provided, you have demonstrated that you are an Afghanistan national who held temporary residence in Ukraine. I do recognise you have lived in Ukraine for several years. However, during the time you spent in Ukraine, you've always held temporary residence. And the point I'd like to take for that for now is that it was accepted he was resident in Ukraine, as the Upper Tribunal does.
Yes.
If I may, I'll come back to the next point in that paragraph a bit later when looking at discrimination. But the conclusion of that section is, at the bottom of that section, having considered all these matters, I'm not satisfied that you have demonstrated there are compelling reasons why you should be issued leave outside the rules. So that's the decision there. So by reference to his arguments under Article 14, the decision maker rejects the Article 14 arguments and then says, therefore, I'm not going to grant you leave outside the rules. So that's the decision. The next section I'd like to look at, please, is the responsible minister's intention or purpose behind creating the scheme. Because this is a human rights challenge, the intention or the reasons for the minister who created the scheme can be relevant to the court's consideration. And they can be relevant because if the minister has addressed a particular matter which is before the court and come to a decision about it, then for standard reasons of democratic accountability in an area of political controversy like this, the court gives weight to the minister's views. At the European level, it's phrased the margin of appreciation. In some domestic cases, they rather refer to giving weight to the minister's views.
But how does that work where the policy is embodied in an appendix to the immigration rules, which has been subject to a parliamentary procedure?
Even if it was legislation, primary legislation, the intentions of the government in formulating the scheme would still be admissible. So cases like Brewster, Brewster is perhaps the most helpful authority on addressing this specifically. That concerned an order in Northern Ireland, and the Supreme Court there explained that if the government demonstrate that they address their mind specifically to the issue which is before the court, then weight is due to that.
Sorry, Mr. Straw, I don't know the Brewster case. I'm sure I should, but the intentions of a minister may be relevant in interpreting the legislation, but why is that helpful here?
It's helpful here because one can start with the analysis in Wilson and First Country Trust that in deciding whether an issue, an interference or a measure is disproportionate under the Human Rights Act, then it's significant for the court to look at the purpose for which the measure was made. So the particular factors of the background to the measure, which are relevant to the question of proportionality. And it may be easier. I'm going to come to Brewster in a moment, and it may be easier just to take their lordship's words in that case.
Okay.
But it's relevant to the analysis as to whether the measure is proportionate. I think it's probably easiest to take the law on this in 3 stages, if I may. So the first is this particular point, and can we turn, please, to the authorities bundle to see the case of Brewster?
Yes.
Brewster is tab 12 or page 321. Brewster concerned a Northern Ireland order which restricted survivors' pension to married partners or civil partners. It also extended it to cohabiting partners, but only if they'd carried out something called the nomination procedure, which was a formal procedure for saying, essentially, we are close enough, we deserve this benefit. The Supreme Court decided that having the nomination procedure was a breach of Article 14, that it should, that the fact that long-term cohabiting partners didn't qualify just as of right without having done the nomination procedure, they said that that was a breach of Article 14. So that's the context. The particular issue that we're discussing now begins at paragraph 48, which is page 337. In paragraph 49 to 52, Lord Kerr discusses this issue. So, what the court should do about, the relevance of the views of the responsible decision maker. And so, Lord Kerr explains that the question as to whether justification for breach of the convention has been demonstrated must be assessed objectively. So, it's a question for the court. That's not to say, however, that the court should substitute its view for that of the decision maker. Indeed, it may be appropriate to accord a wide margin of discretionary judgment to the conclusion of the decision maker, particularly where it's the legislature that makes the choice and where the conclusion lies within the field of socio-economic policy. Now, that case was concerned with a legislative measure in Northern Ireland. It was an order that had been brought into place in Northern Ireland, so it's a slightly different nature to the current one. But similar principles apply. So in paragraph 50, he goes on to say, the margin of discretion may take on a rather different hue when, as here, it becomes clear that a particular measure is sought to be defended, at least in part, on grounds that were not present in the mind of the decision maker at the time the decision was taken. And quotes from a passage from the misbehaving case. What is the position if a decision maker is not conscious of or does not address his or its mind at all to the existence of values or interests which are relevant under the Convention? And it notes the court's scrutiny is bound to be closer. So what we seek to take from that case is, firstly, what's in the mind of the decision maker is relevant. If the decision maker has addressed its mind to the particular issues before the court, then usual reasons of democratic accountability, weight should be given to that. If not, no such weight is necessary.
Who was the decision maker in this case?
In this case, the Minister for Safe and Legal Migration is the key decision maker. So that was the minister responsible.
Yes, but he was a parliamentary under-secretary.
Yes.
Does that mean that if we're looking at the appendix to the immigration rules, he must be taken to be the person who decided that paragraph 7.1 should be included, despite his previously expressed views?
Well, I hope to show that the inclusion of that is consistent with his previously expressed views, but I'll come back to that if I may. But to answer your question directly, the Home Secretary, and I'll come to this document, described him as the lead in this area. So the person, the Home Secretary essentially gave him responsibility for formulating the scheme, for leading on the scheme. And so we say because of that, he's the key person to look at. I mean, Wilson First Country Trust, so even with primary legislation, which goes the whole process through Parliament, the main person to look at in deciding what the intentions behind the scheme were is the responsible minister. So Wilson says one can look at statements made by the responsible minister in the House or otherwise in deciding what the intention is. And we say a fortiori in this case, where this doesn't go through the whole process of parliamentary scrutiny, it's just the negative resolution process. The lead minister is even more centrally placed.
But formally speaking, the decision maker, if that's the right way of putting it, in relation to the immigration rules, is the Secretary of State, because the Secretary of State is required to lay before Parliament statements of the practice that's followed in the administration of various statutory powers.
Yes, formally speaking, but the Secretary of State's entitled to delegate that role to another minister, and as we'll see in a moment, did so here.
I see.
Yes.
So we say that there is a relevant question before the court to look at the responsible minister or the lead minister's intentions in formulating the scheme. In finding out what they were, so it's a slightly different question. How does one find out what those intentions or views were? The approach of the court is, I'm sure, a common sense one. One can look at the ministerial submissions but they're not determinative of what the lead minister's views were. It's a question of evidence and proof. And an authority which is quite helpful, which considered this issue, so what is the relevance of ministerial submissions and other documents in trying to find out what the responsible minister's views were. An authority on that is a case called Stagecoach. Could we briefly look at it, please? It may assist. It's in the authorities bundle at tab 18 or page 491. Tab 18, page 491. This was a challenge by a train operating company to disqualify them from a procurement process. And it's a decision of the High Court, but by Mr. Justice Stuart Smith, as he was. And at paragraph 73, which is on page 516, he addressed the issue of the relevance of ministerial submissions in finding out what the minister's true intention was.
So sorry, could you just repeat the paragraph reference, please?
Sorry, 516.
516, thank you.
Page 73. Sorry, paragraph 73, page 516.
Right. Thank you.
Three lines down in paragraph 73, he explains, documents such as ministerial submissions should be subjected to close scrutiny to discover their true meaning. They should not be read with undue rigour, as if they were a statute, but with reasonable benevolence, bearing in mind that they're written for ministers who may have prior knowledge, general or particular. And then about halfway down that paragraph, there's a sentence starting, the object is, it's the right-hand side of the page. The object is to see whether the minister had sufficient information to enable her or him to make an informed judgment. So that's a different context here. This is a planning decision. And whether the reasoning and reasons for the minister's decision can be inferred from a combination of the briefing and the decision itself. And that's really the point here. In my judgment, it would not be justified to elevate this sensible and necessary step into a presumption, let alone a legal presumption, that a minister will have adopted all of the reasons in a report, in a ministerial submission, even when the minister has made a decision which is in accordance with the recommendations in the briefing. The question is one of inference and proof. The aim is to find what the responsible minister's reasons were for a decision. Ministerial submissions that went to the responsible ministers can be relevant to that, but whereas here we've got actual emails expressing the minister's views themselves, they're obviously of particular weight in deciding what the responsible minister decided. So with that in mind, could we go to the documents, please?
Yes.
The evidence. Thank you. It's in the supplementary bundle now. So please put away the authorities bundle and turn to the supplementary bundle. The first document, please, is the ministerial submission of the 2nd of March 2022, which is tab 49. Page 323. So this is the starting point for the Ukraine family scheme, and the issue at the top there, seeking agreement on detailed policy proposals and draft immigration rules on the Ukraine scheme to allow family members of British nationals, UK settled persons and others to come to or stay in the UK. So the aim there, allowing family members of people settled in the UK to come to the UK. That's the basic starting point. I don't seek to go to anything in particular in that submission. The next stage in the process is that on the 4th of March, the Home Secretary agreed to authorise the discrimination that arose by limiting the scheme to Ukrainian nationals, as we've seen, and their family members, and agreed to do that on the basis of an equality impact assessment that was in place at the time. The reference showing that the Home Secretary agreed to authorise the discrimination on the basis of that equality impact assessment is in the supplemental bundle, tab 61, page 410, paragraph 1. I don't seek to go there unless you'd like me to, but that's just for your notes. However, I would like to turn to the...
I think we probably should.
Okay, thank you.
It's quite short.
It's page 410. That's a ministerial submission on the date 4th of March 2022. And paragraph 1, following my submission, that's Mr. Ramsbottom's submission, of 2nd of March 2022, you, Home Secretary, agreed to authorise the direct discrimination under the Ukraine Family Scheme. This was set out in the Equalities Impact Assessment, EIA, which can be found at Annex 8.
So it seems that the Secretary of State was aware of this point.
Yes. The Equality Impact Assessment is at page 343 of that bundle. And can we go back to that, please? If you have tabs, it's tab 51 or page 343. So this is the Equality Impact Assessment. Towards the bottom of the page, there's a section of background. And in the second paragraph, it notes this Equality Impact Assessment addresses a new bespoke Ukraine scheme. So it's a new scheme. And then policy proposals at the bottom of the page. Going over the next page, so we're on 344 now. Includes in the second paragraph this, so it's 3 lines down in the second paragraph, where a non-Ukrainian national is part of a family unit which qualifies because one member of the family is Ukrainian. We would also seek to include them in the scheme to avoid splitting families where there are multiple nationalities.
I'm so sorry,
I'm sorry, it's page 344, and it's the second paragraph down from the top.
Oh, I see. Yeah, sorry.
The last 3 lines.
I've been slow on the uptake.
No, it's my fault. I'm sure for going too
No,
fast.
it's me. Thank you.
And we rely on that along with some of the other points I'm going to go to here for the purpose of showing that a central purpose, of the Ukraine schemes was to avoid splitting families. It was to keep families together.
Yes.
Could you turn please to page 346? There's a section on 346 headed justification. So again, this is justification. It sets out the policy rationale. The first paragraph in the heading, the section with justification above it, states the policy rationale is set out above and is intended to take a flexible approach to an ongoing conflict. The aim is to benefit the family members of British nationals and settled persons whose situation is such that there's a genuine and imminent threat to life. Again, expanding on the point I made earlier, that a key purpose of the scheme is to benefit family members, but more specifically, family members where there's a threat to life because of the Russian invasion.
Yes.
So that's all I wanted to turn to for the EIA. If I may turn on to the next stage of consideration. On 24th of March, there was another ministerial submission. I don't propose to go there unless you'd like me to, but if you'll note, it's page 354 of the same bundle. And it was a ministerial submission that drew attention to the fact that there were a number of third country nationals who had made applications but were ineligible. And they fell into different categories. So one category, I think there were 71 at the time, was the appellants, the appellants cohort. So it's people, third country nationals, who met all of the criteria of the scheme apart from nationality, but they claimed that they were unable to return to their country of origin. So that was one group. It also identified another number of other third country national groups who had made applications but didn't qualify. For example, third country nationals who met the first three criteria in the scheme but could go back to their country of origin, or third country nationals who didn't meet some of the first three criteria in the scheme. So there was a big group of people who, I think it was 2,000 people, who'd applied and didn't qualify. That was the context for then further advice being given on the 14th of April, 2022. Could we turn to that one, please? It's in the same bundle at page 364. So this is a ministerial submission on the 14th of April 2022. And the issue there is further advice on the approach to be taken to the 2,000 applications under the Ukraine schemes from TCMs which do not fall to be granted. So those are the ones really that have been described in the earlier ministerial submission, the various groups. The overall advice is to refuse applications from third country nationals displaced from Ukraine who don't meet the requirements of the Ukraine schemes. Over the page, there are, well, in paragraph 2, at the bottom of paragraph 2, it said, We've considered the issue further in light of your comments, and there are significant reasons for not including these TCN cases in Ukraine schemes. And so that's all of the different groups. 4 lines up from the bottom. The schemes were established primarily to provide Ukrainians displaced from their country and unable to return a safe place to reside. TCNs in Ukraine, who have the option to return to their home country, are in a fundamentally different position. And the reason for referring to that is, as we'll see in a moment, the lead minister objected to that. He considered that they weren't in a fundamentally different position. But I'll come back to that if I may in a moment. At the bottom of the page, there's a section, Leave Outside the Rules policy, which goes over to the next page. And in paragraph 6 of that section, it's noted, as the Ukraine schemes are fee-free, were we to accept applications from third-country nationals, and in the absence of a fee-free alternative, we would likely see an increase in TCNs using the Ukraine scheme forms to make human rights and other protection-based claims, instead of using the family routes. So one of the concerns there was that were we to accept applications, then we would see an increase in asylum claims, human rights claims. And again, the lead minister addresses that. I'll come back to that in a moment. Paragraph 9 in that section, therefore, so because of those concerns, we are therefore recommending that you maintain the core policy behind the schemes and that you refuse the applications from TCNs who do not qualify under the rules, including TCNs forced to leave Ukraine who have a family member in the UK. What the recommendation seems to be there is that all applications from TCNs are refused, and the lead minister is asked, do you agree? Paragraph 10 then notes, we'll continue to consider any individual circumstances put to us by TCN applicants on the UFS with settled family in the UK that warrant a grant on exceptional or compelling compassionate grounds in line with our existing leave outside the rules policy. So again, that's more evidence of what we saw in the policy document itself, that a policy had been adopted, that for an applicant under the UFS scheme who didn't meet the criteria, decision makers would in any event consider any individual circumstances of that decision in order to decide whether to grant leave outside the rules. The final point from that submission I'd like to come to is just below paragraph 14. So it's over the page.
Isn't it relevant that there's consideration of TCNs from Afghanistan in paragraph 11?
I would like the court to read paragraphs 11 to 14.
Right, Mr. Hill, we'll do that.
Thanks.
Yeah. Thank you. And we agree it's relevant, and those are, I think, summarised in our skeleton.
All right, well, we'll read them anyway.
Thank you. And then at the bottom of that section,
Just a minute.
sorry.
Yes.
So at the bottom of that section, there's then this question: do you agree that we should now proceed to refuse applications made to the Ukraine schemes by TCMs who claim to be unable to return to their country of nationality? Now, it may not be initially clear the difference between that and the point in paragraph 9. The recommendation in paragraph 9 and the question, do you agree, seem to be, do you agree that we should refuse all applications? Whereas paragraph 14 appears to be asking a different question. So do you agree that we should refuse applications made to the Ukraine schemes? That seems to be the distinction. So paragraph 14, if someone makes an application under the Ukraine scheme,
15.
Sorry.
Sorry, I don't understand the inconsistency.
Well, they're two separate questions, and they're dealt with as such by the lead minister. It appears that the first question is, do you think any application should be refused? And the second one is, do you think someone should be found ineligible for the Ukraine schemes? But that leaves the question open as to whether they should be given leave outside the rules.
Well, it doesn't, because paragraph 15 deals with that. Doesn't it? There's the
Yes.
nationality requirement set out in the immigration rules. Should you wish to include TCNs, blah, 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 you would need to agree to introduce a concession to either grant TCNs LOTR or waive the nationality requirement in advance of amending the rules. Further advice can be provided if you don't agree with the recommendations in this submission.
Yeah, and that needs to be read in the context of paragraph 10 as well. So we will continue to consider any individual circumstances to decide whether to grant leave outside the rules. It may become clearer by looking at the ministerial response to this.
Right.
So that is page 361. It's an important document, and we invite you to read all of it. I'm going to refer to some particular paragraphs. If I may pick it up from the bottom of the page, if you've got to that point. So Minister Foster doesn't agree with the premise of the second paragraph, which underpins this submission, that TCN in Ukraine, who have the option to return to their home country, are in a fundamentally different position to those with Ukraine nationality. And he explains why. Minister Foster comments that this argument does not hold up if the person concerned has been forced to leave their home due to war, and a very close family to reside with is in the UK. And notes some may not have an easy option to return, and the core reason for launching this scheme was impact on the ground, not just nationality. Hence the residence criterion. So just pausing there, Minister Foster plainly disagrees that third country nationals are in a fundamentally different position if they're unable to return to their country of origin. And his explanation for that is that a core reason for having the scheme was what he calls impact on the ground. That must be the fact that people are at risk in Ukraine because of the Russian invasion. And that's apparent from his reference to the residence requirement. In other words, third country nationals who can't return home are just as much at risk as a result of the invasion as Ukrainian nationals were, and the core purpose of the scheme was to protect those at risk in those circumstances.
It goes on to say, Minister Foster would draw this tightly to immediate family to prevent abuse and apply to UFS only.
Yes, and that's considered to some degree in the next ministerial submission.
But also, if you go to the final bullet point, Minister Foster does agree that we should now proceed to refuse applications made to Ukraine schemes by TCNs who claim to be unable to return to their country of nationality. Para 14. He comments, unless there's a close family link, which is the basis of the UFS, then the right approach is for them to seek sanctuary in the safe and democratic country they are in.
Yes, and we underlined the words, unless there's a close family link, which is the basis of the UFS.
Yes.
So, again, it's applying
but the close family link doesn't necessarily equate to all the relationships which are set out in the paragraphs you showed us in the appendix to the immigration rules.
No, it doesn't. If I can come back to the definition of close family link in a moment, but just to make a slightly different point, what he appears to be saying there is that if there's a close family link between the TCN and someone in the UK, then there should be an exception. So we shouldn't accept applications by TCNs generally to the scheme, except where there is a close family link between the TCN and someone in the UK. So, applying the reasonably benevolent interpretation, we would seek to draw from that, and this is consistent with a later document I'll come to, that the lead minister considered that TCNs who otherwise satisfied the scheme, apart from the nationality requirement, who were unable to return to their country of origin, but had a close family member in the UK, should come within an exception. So leave by one means or another should be granted to them. And there's a further document that I'll come back to which we say supports that.
At some point in the in the next few minutes, let's take a 5-minute break, but you'll know better than I do what would be a convenient point.
Thank you. We'd like to take a break now.
Right.
All rise.
is cohort was.
Yeah.
No.
I'm keen to. We're obviously, they're obviously a bit lost.
Yeah, that seems to be like kids with
the more complicated, so I'd be really keen to just keep it simple as possible.
Yeah.
So he addressed his mind to the
But
justification.
yes, the justification. That's the thing. Because at the moment we've only talked about his outcome.
Yeah.
We've only talked about the outcome, but the outcome is maybe the main point in terms of what we care about. The outcome helps show that he could reject the justification, and he came up with this other way of dealing with it, which is also our way of dealing with it. And it helps to show he didn't change his mind in the justification.
Yeah.
But I think it's really rejected. Maybe we're going to do that.
Yeah, I think, his so the first one.
Because but he refers to the house. He actually refers back to like the asylum claim.
He refers to 5 to 10, not 11 to 14.
Yes.
But the
Not flagging.
but okay.
Focus.
Well, I
Turn to
think
focus.
is if you're to continue and I have to take over, we're going to have to do this by medium of interpretive dance.
There's another bit like only a certain number of applications.
Yeah, I don't think
that
we
hard?
actually.
Not entirely sure. Yeah. Hold myself together.
Just read the scale.
I don't think that
Um,
to change your mind. He didn't think he had to change his mind. It makes sense. It's a decision, and that's whether there really is a justification. I don't.
The charter is too big to change. questions.
Court rise if able.
Yes, Mr. Shaw.
Thank you very much. We're on page 362 of the supplementary bundle.
Yes.
I think so. The first black bullet point on that page. Sorry, I had come to the first two white bullet points on that page and had submitted that that was evidence that the lead minister rejected the view that people in the appellant's cohort, and so that is people who satisfy all of the scheme's criteria apart from nationality, but show that they're unable to be returned to their country of origin, are in a fundamentally different position. And he appeared to have rejected that on the basis that, so far as the core purpose of the scheme is concerned, the protection of those on the ground, that group is in a similar position to Ukrainians. That's because they're in danger, they can't return to their country of origin. And we'll place reliance on that when it comes to the discrimination questions of analogous position and justification.
Well, just a moment. You showed us a moment ago submissions of the 2nd of March and the 4th of March.
Yes.
And when was on what date was the amendment to the immigration rules laid before Parliament?
29th of March 2022.
Right. So, and might have been subject to negative prayer, but there wasn't one. So that, and then the guidance to caseworkers, tab 37, was that shortly afterwards?
So there was that was not until until December 2023.
Oh, I see. Right, that's much later.
There was a previous version in the version 4 version, which was in place from the 11th of March 2022.
Okay, right. So this is some weeks on. The amendment to the rules is in play.
Yes.
The guidance, 2022 edition of the guidance is in play. So what is the formal question that is being considered in this memo from the Home Secretary's private secretary to Mr. Gallagher and others?
Yeah. It's really a response to the 14th, it's a direct response to the 14th of April MinSub, but that itself came out of the 24th of March one, which was the one that said, hang on, we've got a lot of applications from third country nationals who don't qualify under the scheme in these various different groups. What are we going to do about them?
It looks from the third white bullet point as though what was being considered was some tightly drawn amendment to the rules. Or
Yes.
perhaps to the guidance as to how they should be applied, but probably more likely the rules. But did that ever happen?
I'm hoping to come to it, but
Okay.
there was no. The short answer is that there was no amendment to the immigration rules, and nothing specific that came out in guidance. But there was a consistent expression by the lead minister that leave by one means or another, whether that's leave outside the rules or otherwise, should be granted.
Yes.
To this. For our purposes, we're only
sorry.
concerned-
Forgive me for interrupting.
Not at all.
The 24th of March memo says of the group, including your client, at this stage we'll maintain a hold on these cases while we work through policy and legal options. So that's still in play.
Yeah.
But then the final black bullet point does agree we should now proceed to refuse applications by TCNs who claim to be unable to return to their country of nationality.
And again, we emphasise unless there's the close family link. So what read as a whole and in context, the lead minister, it's tolerably clear that he meant is that those in the appellant's cohort, so people who meet the other criteria in the scheme, who are resident in Ukraine, who have close family in the UK and are unable to return home, there should be an exception. So there's an unless in their case.
Yes, right. Thank you.
Thank you. And so just briefly, I know you've read it, but just to draw attention to the first black bullet point on that page, the concern had been raised in the ministerial submission about the ability to prove or disprove residence, and Minister Foster is to reject that, commenting that the risk is present already. And then the second bullet point refers to paragraphs 5 to 10 of that previous submission, which were concerned with the leave outside the rules policy. And the main point being made there appears to be, well, if we allow applications here, that would encourage people to make asylum claims from abroad. That was paragraph 6 of that ministerial submission. And again, that appears to be rejected by the minister, who comments that these arguments are ones which go against the routes as a whole. Asylum claims can be made regardless of whether an exception is made, that they can be made on the forms already. And he is concerned with the recommended approach. So that appears to refer back to paragraph 9, which said, do you agree about refusing all applications? there's further discussion. And if I can move on to the next min sub in the process, it's the 6th of May 2022, page 371. This was considering the approach to all third country nationals. It wasn't just the particular cohort with which this appeal is concerned, people who can't go back to their country of origin. It was all third country nationals. The question was, should we do anything about them? And page 373, in paragraph 6 to 7, they discuss a point about a risk of discrimination. So they say, paragraph 6, there's a risk that opening up the scheme to TCNs might generate potentially abusive applications from people who were not resident in Ukraine. So people who weren't resident there but coming in pretending they were. Given this and the relatively light touch approach to evidential requirements for Ukrainians under the scheme, you've indicated that you are minded to operate a different approach to evidential flexibility. We have very little rationale or evidence base for doing so at this stage. Caseworkers would still be able to request further evidence when there are concerns, including of residence in Ukraine prior to the 1st of January. Caseworkers would be more likely to do this when a person is unable to share any links to Ukraine, such as a Ukraine passport. As such, we do not believe we would derive significant benefit from a differential approach. And a similar point is made in paragraph 7. So as the current policy already allows further checks to be completed, we do not consider there would be a strong rationale for taking a different approach. The ministerial submission appears to be saying here that there's this identified risk of abuse with allowing all third country nationals to come in. All third country nationals, that is, who have a sponsor in the UK who they're related to. And the risk is that people who weren't resident in Ukraine will abuse the scheme and will come in because they'll take advantage of our lower evidential requirement. To guard against that risk, you've suggested having a higher evidential requirement for those third country nationals. And what the ministerial submission appears to be saying is there's no need to, because we already have a flexible standard. And so what they seem to be saying there is that there's no benefit. There's already a flexible approach to evidence. One can already ask for further evidence if you're not convinced. And indeed, when someone was a third country national, that may well be the circumstance where asking for further evidence is appropriate. The reason for referring to that is it's a point that's relied on by the upper tribunal, and I'll have to come back to that a bit later to make submissions about that. In any event, the recommendation from that ministerial submission was to continue to exclude third country nationals as a whole, with no immediate or extended Ukrainian family members, from the scope of the UFS scheme. And on the 17th of May, there was an email recording the ministerial response to that. And that's at page 378. Could you please read the substance of that email?
Yes.
Thank you. So the last paragraph, the Home Secretary has noted, indicates that the Home Secretary has delegated the work in that area to Minister Foster as the lead. The second big paragraph, Minister Foster has also noted achieving his thoughts. That seems to refer back to his earlier thoughts about third country nationals who are unable to return to their country of origin. And that appears to be the case because he says there that he makes a suggestion about achieving his thoughts through the family route. He said that there could be lines about what happens if a refused TCN, who was forced from Ukraine by the Russian invasion, has a close family member in the UK, and little funds or support to return to their country of origin. So it appears to be concerned with the appellant's cohort, people unable to return to their country of origin. And again, reading this against the context of the other comments that were made in that email that we looked at earlier, in my submission it's tolerably clear that the lead minister maintained his view that the appellant's cohort, people unable to return to their home country with close family in the UK, should by one means or another be granted leave.
But, sorry, Mr. Straw, I don't understand this. So what? In the first paragraph, it says that both Mr. Foster and the Home Secretary have reviewed the submission and agree with the recommendation and decline to bring third country nationals within the scheme. I understand that your case is that decision is wrong because of Article 14 taken with Article 8 and so on, but I don't understand why the fact that Mr. Foster evidently had qualms about it is either here or there.
Well, for two reasons. Firstly, there's two parts to the policy. So there's, on the one hand, whether to grant leave under the Ukraine family scheme.
Yes.
And then the second part of it is whether to grant leave outside the rules. So for people who don't qualify for the scheme, whether to grant them leave in any event. And we're focused really on the second part. So we say his intention was, by one means or another, that people in the appellant's cohort should be granted leave outside the scheme. He clearly concluded they shouldn't be granted leave within the scheme.
Yeah.
In other words, there shouldn't be a specific exception. But we say it's sufficiently clear, looking at the preparatory documents, that he considered that outside the scheme they should be granted leave.
But again, so what? The passage that you showed us about leave outside the rules doesn't reflect that at all. So you're saying we've got to read that passage as if it says something it doesn't say, or what's your submission?
No, my lady, our submission is that some of the questions as to whether Article 14, the interference with Article 14, the difference in treatment, is justified, have been addressed by the minister who's responsible for the scheme. So the questions include the analogous position question, whether the appellant's cohort is in an analogous position to people who qualify, and also the question of justification. So is there a difference as concerns the core purpose of the scheme between the appellant's cohort and those who qualify? And that's something that the lead minister has apparently addressed, and he's considered there isn't that significant difference. And for standard reasons of democratic accountability in this area, it's important that the court gives his views weight as the person who's responsible for the scheme, see Brewster.
But what if his boss, the Secretary of State, doesn't agree?
Well, she here notes that she's delegated essentially the task to Minister Foster. So it's Minister Foster's role to lead on work in that area.
Yes, but that doesn't mean the Secretary of State, whoever the Secretary of State then was, has abdicated overall responsibility. Because after all, it's the Secretary of State who lays the immigration rules before Parliament.
Yes, absolutely. But nor is there anything that suggests that the Home Secretary disagrees with Minister Foster's views. The ultimate design of the scheme is entirely consistent with his views, namely that although the appellant's cohort doesn't qualify under the rules for the Ukraine family scheme, that's not the end of it. There's still this question: should you be giving leave outside the rules? And
But there's no steer in the bit that deals with leave outside the rules that reflects what you say his views were.
No, it remains the policy as ordinary, but those are still clearly, well, we say it's tolerably clear that those are his rules, and sorry, that those are his views. And when it comes to the question as to whether the difference in treatment was justified, those are important factors to take into account.
Well, all that it shows is that there is room for more than one view in government and in the civil service. But so what? It's been considered by everybody who's thought about it.
Well, so far as the point that we're directly relying on is concerned, which is that people who fall into the appellant's cohort ought to be granted leave in one way or another. There don't appear to be different views. The only view that's expressed in the documents is that of the minister who is responsible for the scheme, and it's not contradicted by anyone. No one says we disagree that they're in the same position. We disagree that they should be granted leave.
What happened after this document? The next document, by the next document in the bundle, your solicitors have written to indicate a claim. But was the sequence of submissions and meetings and so on taken any further?
That's the end of that series. It's revived. The issue is revived later when a person makes a judicial review claim whose name is MB, who was again someone who said he was unable to return to Afghanistan, and he had a brother who's in the UK. And a ministerial submission is produced which says, what should we do about this? Should we change the...
Is that the one at page 360?
It's at 380.
Oh, right, okay. 380, I'm sorry.
No,
my fault. Very small numbering.
Yeah.
Okay, but that's not your client, but it's somebody in a very similar position.
Yeah.
Okay.
And it's summarised in our skeleton at 21. Essentially, the question is, should we change the criteria in the scheme? And the answer is no. The Ukraine family scheme criteria should stay the same. But it's worth noting that MB was granted leave outside the rules.
But your grounds of appeal are focused entirely, and as was the judgment below, on whether the Ukraine family scheme or the parallel HUSS scheme is fatally flawed because of incompatibility with the convention. It doesn't say you're not attacking the failure or refusal to grant your client leave to enter outside the rules.
In fact, that is what we're attacking. We are specifically attacking the decision not to grant him leave outside the rules, rather than the terms of the Ukraine family scheme. So it's a case about the individual decision in his case, the decision not to grant him a visa in his specific case. It's not a systemic challenge to the terms of the Ukraine family scheme, with one minor exception, which is put in the alternative. And that was the case in the below. So the grounds of the application below are in the core bundle at page 232, paragraph 67, and then likewise our skeleton argument. The first three grounds are focused on the specific decision in this case, so the decision not to grant leave outside the rules. So, my Lord, I hope that's set out in our skeleton in particular, paragraph 3, but also the remedy that we identify in our skeleton argument is paragraph 67. So, declare the decision to refuse to grant a visa and permission to travel were unlawful as being incompatible with Article 14 and Article 8. Perhaps I can come to the grounds of appeal, and it may be clearer as to exactly what we're saying. Apologies if it isn't clear until now. So, can I turn to ground 1, please? Under ground 1, we say, in summary, that the upper tribunal erred because it didn't give considerable weight to the views of the responsible minister when deciding whether there was a breach of Article 14.
Sorry, I'm looking at the grounds of appeal, page 66. Is that the wrong document?
That sets out the grounds in outline, and then they're expanded upon in our skeleton argument.
Okay.
So it's probably easier to look at the skeleton argument if that's okay. And so ground 1 is page 10 of the core bundle, paragraph 3.
Yeah, all right. But can we just go to the formal grounds of appeal first?
Of course.
That's pages 66 to 68. It seems to me to be all about the scheme. And the judgment below is the relevant parts are all about the scheme, aren't they?
Well, that's our main criticism of the judgment below, that we say our original case was an attack on the individual decision in his case. It was an attack on the decision not to give a visa. And the upper tribunal focused on the scheme as a whole and didn't focus sufficiently on the individual circumstances of his case.
But paragraph 3 there are some introductory paragraphs of the grounds of appeal, and it said in paragraph 2, appeal real prospect of success. Further alternative, the appeal concerns whether excluding certain third country nationals from the Ukraine schemes who otherwise met the relevant criteria was lawful. Now, I read that as an attack on the scheme.
Well, that's the broad issue, but then further detail is given to that below and in the skeleton argument, where it's clarified that the question is to whether there was a breach of Article 14 of the appellant's Article 14 rights. And
Well, of course, he's your client. You're not. The 71 other people are not your client. But what I'm trying to say is, it seemed to me that the appealers, as presented, both the grounds of appeal and the skeleton argument, are saying the Home Secretary was wrong to refuse a visa because if the Ukraine family scheme had not had this discriminatory provision requiring Ukrainian nationality, then he would have been eligible, indeed entitled, to be admitted under the scheme. You don't say, alternatively, even if all that's wrong, he should have been given leave to enter outside the rules.
The issue might be that in order to ask whether there was a breach of Article 14, one has to look at the criteria within the scheme. So the question is whether there's a difference in treatment on the grounds of nationality, and for that one needs to look into the criteria in the scheme.
But paragraph 6 of the grounds of appeal under the heading Article 14 ECHR. First of all, paragraph 5, the tribunal erred in holding no violation. 6, the tribunal erred by concluding that the difference in treatment between the appellant and Ukrainian nationals qualified for the Ukrainian schemes was justified. Again, that seems to be the point about the scheme.
We respectfully say no, because it's about the appellant and someone who qualified. So we're not saying that he did qualify. We're saying that the particular decision in his case to refuse him leave was discriminatory. If he'd been a Ukrainian national, he would have qualified. And that was unlawful. That violated Article 14 ECHR.
Okay.
So we say it's clear in our skeleton below, in the grounds below, and when the grounds here are read together with our skeleton argument, it's also clear that we're concerned about the decision in his. We're primarily concerned about the decision in his particular case.
Yeah.
One place one can look to for that is the summary of the grounds in the skeleton argument, and then also the section on relief.
And there is reference to discretion at the very end of the judgment below, paragraphs 95 and 96. And they say, we didn't hear any detailed oral argument. We don't think this ground of challenge adds anything of substance. No, it didn't seem to me in the grounds of appeal you were revisiting that.
I mean, one place to look is our skeleton argument, ground 2. So we say there, referring to that paragraph, the tribunal erred because it failed to conduct an individual assessment of whether the difference in treatment was justified by factors that were applicable or relevant to Edis' individual case. It relies on factors that were relevant to whether a bright line approach was justified, but most of those weren't relevant since the scheme provided for leave to be granted in light of the particular circumstances of the individual's case. So again, it's focused on granting a visa to the applicant outside the rules in light of the circumstances of his case.
it still goes, the underlying complaint is still the discrimination inherent in the scheme. I see how you can say, in layman's language, well, if the scheme had this discriminatory factor, he nevertheless should have been admitted because of the discriminatory flaw in the scheme. Not alternatively, he should have been admitted as a matter of general discretion because he's a good chap, which I can see in many respects he is, but that's not how the case was put below, and it's not how you put it here, is it?
So as to how it's put below, the grounds of appeal, the judicial review, below are at 212 of the core bundle, and in paragraph 6 of that, so that's page 3, the appellant submits that the refusal of the visa is discriminatory on grounds of nationality.
Yes.
And then the remedies are orders.
But it goes on to say the matter falls within the wider ambit of Article 8 since it concerns a visa scheme set up by Secretary of State, blah, blah, blah. Therefore, Article 14 is engaged.
It may become clearer as to this issue may become clearer if I can get to the case law.
All right. Well, you carry on, Mr. Straw.
And then the third ground is Secretary of State's refusal to exercise their discretion outside the rules is inconsistent with the Human Rights Act and so on.
Yes. Well, that's seemed to me what the upper tribunal were addressing it very briefly at paragraphs 95 and 96 of their judgment. It didn't seem to me they were challenging that. But you carry on for the moment.
Thank you. Just on that, the 95 and 96 are about the Article 8 aspect.
Oh, right. Well, that's even less before us because Lord Justice Lewis refused permission.
That's right.
All right. Let's return to Article 14.
Thank you. And I hope it'll be clearer as to exactly how we put the case. If I can look first at the case law and then come back to our arguments on that. Ground 1 is a relatively short ground. We submit that the upper tribunal erred in the way it treated the lead minister's views. It should, we say, have given considerable weight to those views, and it didn't. And in addition, it misunderstood his views. It's in several places said that the respondent, the Secretary of State, was entitled to conclude something, entitled to decide something, when there's actually no evidence that they did, and in fact, the evidence indicates that the lead minister came to a different view to that. So that's a summary of ground 1. The law is briefly set out in paragraph 32 of our skeleton argument. The key case is Brewster, which I've already described. And so I don't think I need to go to any of the other authorities unless you'd like me to. The main point is the one I hope to have already made, that in an area, a sensitive area of political sensitivity like this, for reasons of democratic accountability, if the responsible minister has expressed a view on an issue which comes before the court, then the court should give it weight. It's a relatively straightforward point. There's a supplementary issue in paragraph 33 of our skeleton argument, which is what does the court do about a witness statement produced for the purpose of defending a judicial review claim, which was produced by a civil servant. And so these are the witness statements of Mr. Ramsbottom, in particular, which the respondent places pretty heavy reliance on. And we say that the usual, the Ermakov approach is appropriate. So by that I mean that the court should be very cautious about evidence produced for the purpose of defending a judicial review claim, and if there's any of the evidence which is inconsistent with the reasons given by the decision maker, then that evidence should be discarded. It's the reasons of the decision maker which stand, which are most important.
But that line of reasoning applies where you have generally you have a decision made by a public law decision maker in an individual case, and the reasons for the decision are given contemporaneously, and then there's a challenge to the decision, and the decision maker comes along after the event and tries to supplement the reasons given in the decision with a witness statement. But that's not what's going on here, because we don't have a reasoned decision of that kind here. What we have is a published policy in support of published immigration rules.
Yes, there are clearly differences between the two. We rely on a case of Lana because Ermakov was originally just about reasons challenges, whereas Lana was a broader issue. It was a failure to have taken into account a relevant consideration. And the court said, well, the point in Ermakov applies more broadly than just to reasons challenges. But we accept that even both of those cases are different from the present context. But it's the point of principle that underlies them. Our argument is the first stage in it is the Brewster point, which we say that if a responsible minister has expressed a view on a matter that's relevant to the court in considering a human rights case, democratic accountability indicates weight should be given to it. That's the first stage in the argument. The second stage is, as a matter of principle, if a civil servant produces a witness statement which contradicts what the minister was saying, what weight should be given to that? That point is partly dealt with in Brewster. So in Brewster, a similar thing happened. There were what were called, I think, post hoc reasons given in a witness statement for the purpose of defending proceedings. And the court said, well, one can take those into account, but one gives much, much less weight to them. And the Supreme Court there basically dismissed them because there's no issue of democratic accountability.
It's often better to consider the actual facts rather than the abstract. What is it in Mr. Ramsbottom's evidence that you say should have been ignored on the Ermakov principle?
Very much take the point, and it may be easier though if I look at what we say from the lead minister's views should have been given weight.
Well, we've seen the sequence of the correspondence, so none of that is Ermakov. Mr. Ramsbottom or anybody else is entitled to exhibit the sequence of letters and min subs and memos and so on. That's what people were saying at the time. Ex post facto rationalisation is when later somebody says what the minister must have been thinking, or what reasons he may have had in mind which didn't find their way onto the printed page. But is there any of that?
I suppose the coming back to your Lordship's primary question about looking at the facts of this case, it's probably easier if we just say these are the parts of the lead minister's view that we rely on. If there's anything that the respondent relies on that's inconsistent with that from Mr. Ramsbottom's statement, we invite you to be very cautious about that. It may well be that there's nothing that they seek to rely on that contradicts it.
All right.
But I hope that's an easier way of coming back to the point.
Okay.
I hope, given what we've done, I hope I can briefly deal with our submissions on ground one. The first point is about the overall consistent approach that we say that the lead minister had in this, and as I have already said, at risk of repeating myself, we say, looked at as a whole in a benevolent way, it's apparent that the lead minister considered that the appellant's cohort, people who were unable to return to their country of origin and who had close family member in the UK and met the other criteria for the scheme, should be granted leave one way or another, whether that's outside the rules or by some other route. And we say that it was important to give that weight because it's the expression of the minister who was responsible, and the upper tribunal didn't, and in failing to do so, they erred. On that point, I said I would come back to my lady's question about the meaning of what the minister was concerned with here. He said in the 2 emails that we looked at, he referred to close family members. That's not defined, close family member isn't specifically defined in the context of the Ukraine schemes, but it is defined in similar contexts. And one example is, I handed up a document earlier on, the Home Office policy on adult dependent relatives, family policy.
Yes.
It may be that this helps. Close family member is defined in that, and it refers on page 13. So this comes within a section on assessing the requirements for adult dependent relatives. It's a different context, but it's the immigration context. And then on page 13, the heading, the section headed, no person in that country who can reasonably provide that care. The ECO should consider whether there's anyone in the country where the applicant is living who can reasonably provide the level of care. This might be a close family member, son, daughter, brother, sister, parent, grandchild, and so on. So their close family member includes sibling.
So you're saying that we are to infer that that's what Minister Foster had in mind when he said whatever he said to the civil servant, who then recounted his thoughts in the email that we were looking at?
I'm saying that that's the best answer I can give to Malaysia's question.
Right.
In other words, close family member isn't defined
And was
specifically
this
in the rules.
policy in existence at the relevant time? This is the 7th of August
Yeah.
2023.
So the decision in February 2024. In terms of when the lead minister was expressing his views about close family members, that was in 2022.
That's
So
what I thought.
this was a later version. We can certainly try and find the
you
one.
can
that
check.
was
I suspect it hasn't changed much, but could
Because he may
you
simply have been using it as a proxy for the phrase immediate family member, which does appear in the relevant documents. How do we know?
Yeah, as I say, that's the best answer we can give. There's no more specific definition of close family member.
well, if Miss Nall could check over the lunch break whether whatever version of the family policy was in force in early 2022 had the same classification, in particular that siblings are close there, they're not immediate.
Yes.
Then we'd be grateful. Right. Where do we go next?
So that's our key point about this central intention of the lead minister should have been given considerable weight. We also, in the skeleton argument of paragraphs 29 to 30, deal with other aspects of the upper tribunal's decision, where it said the respondent was entitled to come to certain decisions. For example, entitled to be concerned that large numbers of third country nationals would apply, or entitled to consider that there was a bespoke scheme in place for Afghan nationals. That refers to ARAP. and our basic point in response to that is that's not what the lead minister said. That's not what the Secretary of State said. It's inconsistent with some of the points that we've seen the lead minister said. And it's important because the upper tribunal there appeared to be saying, well, the Secretary of State came to this conclusion and considerable weight should be given to that. So the terms entitled to come to that conclusion indicate that the upper tribunal was giving some weight to the Secretary of State's decision. And so the fact that, in fact, the Secretary of State, the lead minister, didn't come to that decision.
But the Secretary of State is not going to come to detailed decisions on every aspect of a policy. And if there are documents which record that civil servants have expressed particular views, and in the end those views are adopted, why can't they be attributed to the Secretary of State under the Carltona principle?
Well, it's a matter, in the words of Stagecoach, of inference and proof. And of course, if there's recommendations in a ministerial submission and there's no suggestion that those have been rejected and the policy recommendation is also accepted, then absolutely, that's the right.
Because ultimately, the points that you have made, the points you've made about what the lead minister thought at various stages, are not reflected in either of the published documents. So why doesn't one infer from that that the advice that the civil servants gave was ultimately accepted by the Secretary of State and the responsible minister?
But they are reflected in terms of the key point, which is that the appellant's cohort should be granted leave by one means or another. But they are reflected in the ultimate design of the scheme because leave outside the rules can be granted.
Yes, but the passage that talks about leave outside the rules does not reflect a policy decision that people in the appellant's cohort should get leave outside the rules. It simply doesn't have that effect.
Absolutely. There's nothing specifically, explicitly in it which says that should happen, but nor is there anything inconsistent with the lead minister's view. As I understand the point being made against me, is that well, the ultimate design of the scheme shows that the lead minister's view was rejected, whereas we say it can perfectly well be accommodated by granting leave outside the rules to the appellant's cohort.
Yes, but there's no steer for decision makers. So if you wanted to say that this policy has been adopted and is reflected in the relevant guidance or scheme, if there's no steer for decision makers to say everyone in this cohort gets leave outside the rules, then I at the moment I'm not understanding how the policy as finally published reflects that view.
Yes, we put it in a slightly different way. So we're not arguing that the decision maker acted unlawfully because they failed to follow the Secretary of State's policy or something along those lines. We're rather arguing that there was no justification for the difference in treatment here. And we rely on that, on the Secretary of State, the lead minister's views, who considered that the appellant's cohort should be given leave. And those views, we say, should be given weight, see Brewster, see the other cases we rely on in our skeleton argument. So
but if the position was on the 4th of March, the Secretary of State and the Parliamentary Undersecretary jointly accept some advice, and by 17th of May, the Home Secretary has decided not to include TCNs under the scheme, but to put it in layman's language, the Parliamentary Undersecretary is still bothered about it and wanted to explore whether something should be done. But nothing is done. Where does that get you on your attack on the scheme? Sorry, I didn't put that very well. I understand that you say that the scheme is discriminatory, that discrimination on the grounds of nationality, you say, requires compelling justification and so on, and the fact that Mr. Foster was unhappy about it, shows that there are two perfectly reasonable views. But I don't at the moment see why the fact that he was the lead minister, in the sense of the junior minister who was going to be concerned with the detail, reinforces your case in attacking the scheme.
It's probably my fault for not going to the Article 14 case law first.
Right.
But
All right, let's go there.
if I can just briefly summarise to try and respond to that. But the one of the key questions in asking whether difference in treatment is justified is whether there is a distinction between the appellant and those who qualify in terms of the core purposes behind the scheme. And I'll come to a couple of cases to try and make that good in a moment. So a question is there a significant difference between the two of them so far as the core purpose of the scheme is concerned? The lead minister expressed the view that there isn't. And our argument is, well, that's an issue before the court. The responsible minister has expressed a view about it, and weight should be given to that view.
All right.
So it comes in a slightly different way. But I hope that will become clearer when I come back to the
All right.
Particular facts. That's all I hope to say about ground 1. So ground 2 brings in all of this case law. Under ground 2, in summary, we say that the upper tribunal erred because in deciding whether the difference in treatment was justified, it focused on generic or macro factors and the question as to whether the difference in treatment was justified by those generic or macro factors. In particular, it asked whether I'm sorry, could you just give me a moment? I just need to refer back to an earlier document. Thank you. So the upper tribunal, in deciding that the difference in treatment was justified, focused on generic factors, and we say that those generic macro factors weren't applicable to the appellant's case. We say that the appropriate approach that should have been taken by the upper tribunal was to first ask whether a bright line rule which excludes individual consideration of the facts of the case, of the relevant facts of the case, whether a bright line rule is justified. And we say that a bright line rule which excluded individual consideration wasn't justified because it in any event was required. So the policy required individual consideration of the relevant factors when looking at leave outside the rules.
But I'm sorry, I'm just not following that. If there are 2 stages to the policy, do you qualify under the terms of the policy? Answer no, because you're not a Ukrainian national. But then there's a second stage in the policy which says, are there exceptional circumstances which mean you should get leave anyway? I just don't understand what the problem is.
Well, take the key point made by the upper tribunal was about residence, where they said a bright line rule which excluded consideration of the question as to whether the applicant was resident was justified because it said more than this, but essentially it would cost more. So one of the justifications for not considering residence would it would cost more. There would be greater resources in deciding whether the applicant was resident. And we say individual consideration as to whether the applicant was resident was required in any event. It occurred in this case. A conclusion was come to that he was resident. It was consideration of that factor was required firstly by the Ukraine family scheme and alternatively by the leave outside the rules policy. And so there would be no additional cost, no resource implication of giving individual consideration to residents. It was done in any event.
In his case,
Yes, and it was expected under the policy as well.
but it might not have caused a problem in his case, but there might be cases where it would require investigation. So you're saying because it didn't require investigation in his case and a decision could be reached without investigation, there's no justification for the bright line rule. Is that what you're saying?
Yes, we're saying that the question in bright line rule cases is whether there was a justification for excluding the appellant's cohort. So cases where residence is considered, as is expected by the policy, and in cases where a determination is made, as in these cases, that the individual was resident, then we say there's no justification for refusing leave on the basis that it would cost more to try and determine residence. There's no basis for a bright line rule in these cases. The fact that leave is granted in these cases doesn't require it to be granted in the cases where it's unclear whether the individual is resident. In those sorts of cases, there may well be a justification for not going further and analysing the particular facts. And if this had been a case where the Secretary of State had said, I don't find that you're resident, you don't have evidence to show you're resident, it's going to cost far too much for me to investigate whether you're resident, then this would be a different case. It may well be that the discrimination was justified in that case. But the fact that there would be problems assessing, the fact that it would be unclear in a different case as to whether the person qualifies doesn't show that the discrimination in this case is justified. And I hope to come to a couple of authorities which explore that sort of point.
But so perhaps I'm misunderstanding it, but the effect of that argument seems to be you can't have a bright line rule about a threshold criterion at all, because in each case you could investigate all sorts of things and then make a decision on the facts of that case.
Well, we have a couple of cases that I'm going to come to. One of them is Re G, which is the case about adoption, so whether unmarried couples should be allowed to adopt. And Re G found that the rule preventing unmarried couples from adopting was unlawful. It was a breach of Article 14. And one of the reasons for that, I'll come to it in a moment, was that a justification had been put forward for having a bright line rule, which would cost, it would be administratively inconvenient. And that has to be rejected because individual consideration is required in any event. And the House of Lords' ultimate conclusion was that in order to comply with Article 14, there needs to be individual consideration as to whether the adoption was in the child's best interests. Now,
Sorry, but I'm not sure that cases about adoption help very much. I'm still at a very basic level of failing to understand whether you're saying that, in principle, bright line rules in immigration rules are wrong. I thought the whole scheme of the immigration rules and immigration law is that the immigration rules lay down bright line rules, but there is discretion to grant leave outside the rules. Now, so here there has to be some bright line rule as to whether somebody qualifies under the Ukraine family scheme. The two essential features, apart from family connections, seem to be that the applicant must have been both ordinarily resident in Ukraine at the start of 2022 and Ukrainian national. And I thought your attack was saying that the second bright line rule, the requirement for Ukrainian nationality, was discriminatory, contrary to Article 14. But does that mean that there shouldn't have been any nationality requirement at all?
We say that the first question is whether a bright line rule which excludes consideration of the relevant factors, and here the relevant factors are in particular residence and ability to return to the country of origin, whether a bright line rule which excludes consideration of those is justified. And authorities, which I'll come to, indicate if that individual consideration is required in any event, then that bright line rule isn't justified. So, so that's
So then, but then if no bright line rule other than residence was justified, you'd be saying that anybody could apply who could say, I was resident in Ukraine on the 1st of January 2022, and when the Russians invaded, I want to get out. That's all I have to show you, and then you have to consider the case individually.
Someone can apply and make those arguments already, but there's obviously no.
But doesn't it depend on the nature of the bright line rule and the nature of the individual consideration that will be required in any event? So
Yes.
one can absolutely see in the case of adoption, it may well be pointless having a bright line rule excluding certain categories of people from being able to adopt children, precisely because you don't just by being in a category get to adopt children. There has to be an incredibly detailed, individualised process of assessment by social workers that goes on for years in some cases. I mean, one can see the reasoning in Re G, but I'm just not grasping why you can't have a bright, as my lord has just put to you, why you can't have a bright line rule in a field like this.
There are a number of other authorities which cover the same ground and reject a bright line rule on the basis that individual consideration of the relevant factors was required in any event. And I'll come to those in a moment.
Right.
Our case, and it's worth starting with the first aspect of our case is at the first stage one has to look at whether the bright line rule which excluded that consideration was justified. And those authorities show that if consideration is in any event given to the relevant factors, then the bright line rule isn't justified. In other words, no extra cost or resources would be expended on individually considering the question of residence because it's considered in any event. So
But it's
will
only
be
considered in any event because it's part of the criteria for qualifying.
and if it's
I mean,
raised,
this just strikes me as being incredibly circular.
it may become clearer once I've gone to the authorities.
All right, but at the moment you do seem to be accepting that part of your case is a challenge to the existence of a bright line rule, which I thought earlier on you were suggesting wasn't part of your case.
There are two types of challenges that are sometimes described in the authorities here. One is systemic challenges, so a challenge to the scheme itself, and a second is a challenge to the refusal to give the benefit in the individual case. And we're in the second category. However, in deciding whether the decision not to grant leave outside the rules to the appellant was a breach of Article 14, one has to look at the rules, because one of the questions in Article 14 is, was there a difference in treatment on the grounds of his nationality? And there was here, and the reason that there was that difference in treatment was because of the rules. So it's necessary to start with the rules, but one goes on to look at the individual circumstances of his case later.
I mean, the scheme could have said, you must be must have been resident in Ukraine on the 1st of January 2022 or whatever the date was, and either you must be a Ukrainian national or you must be a national of a state to which you cannot safely return. That would still have been a bright line rule, maybe not quite as bright as saying, or it could have scheduled a list, Afghanistan, Somalia, or whatever. For your client's purposes, it would have been enough to say you could be either Ukrainian national or an Afghan national. That would still have been a bright line rule.
Yes, and if this, if the scheme had said, if the policy as a whole was that you either qualify under the Ukraine Family Scheme and then you get leave, or you don't and then you don't get leave, then that would be a very different question. But here there's the second stage, that even if you don't qualify, we consider leave outside the rules. And as part of that process, as happened here, the Secretary of State considers all of the individual circumstances that are put forward. And so there's not going to be an additional cost of considering residence for an applicant because it's considered in any event in the leave outside the rules process. So when
suppose somebody claimed to come to the UK under the scheme, and the facts were that he, let's suppose, a single man, resident in Ukraine on 1st of January 2022. He's a Frenchman. So one would have thought he could, or a German, or a Spaniard, or he's a national of a safe Western European country which is not at war. Under the scheme as drafted, he could be turned down. You're not a Ukrainian national. Yeah. But if it's wrong to have the bright line of nationality, then why shouldn't somebody like that apply?
We're concerned with, we say that the question here is whether a bright line rule which excludes consideration of the factors relevant to the appellant's cohort, which we say are residence and ability to return to his country of origin, whether that was justified by some legitimate aim. And the aim that's put forward against us is, well, that would cost more. There's a resource burden of considering those individual factors. And our argument is, well, there isn't, because consideration is in any event given to those factors. So when our client applied, in considering the leave outside the rules question, the decision maker looked into whether he was resident. There's no additional cost that will be involved in giving consideration to residents. And so that's the limited point we're focused on at this stage, which is that there isn't a justification for a bright line rule which excludes consideration of those matters. It's done anyway.
All right, we'll break off there. Resume at 2 o'clock. Thank you.